Let me just ask you this question. You know, these are things that bother me. I mean, is it the government's position that when our country is engaged in a war, that the power of the executive when it comes to wiretapping is unchecked?
It is not, Your Honor. And that's why we're here today.
But what are the checks on it? If we're getting affidavits from folks in the executive branch and we have to take their word for it, what is the check?
Your Honor, this Court plays an important role in evaluating the legitimacy of the government's assertion of the state secret's privilege. And of course, other courts.
How do we do that?
Your Honor, you look at the in-camera submissions, and our position is the district court was correct that those submissions establish that there is, at a minimum, a reasonable danger that litigating this action could result in exceptional harm to national security. And of course, there is a whole other branch of our government, as other courts have recognized, that is open and available to address perceived claims against the executive. This Court's role
what is that, impeachment?
The Congress, as the Fourth Circuit has recognized, the D.C. Circuit has recognized.
You said there are other avenues. What are the other avenues?
Well, certainly Congress has already undertaken inquiries into issues. But the point is that plaintiffs don't have the ability in this context to come into court and force the disclosure of matters that would compromise national security, force the disclosure by litigating issues that directly implicate state secrets.
Let me stop you and ask you this question. Has Judge Walker made that determination? In other words, has he determined, after looking at the top secret information, that the case cannot go forward without the disclosure of that information?
Judge Walker believed that the case could go forward. Could go forward.
And we think that was ordinarily in a piece of litigation where there's some contention that state secrets may be involved. The ordinary course, wouldn't you agree, would be to let the litigation go forward, and as the government asserts the privilege, the Article III district judge looks at the information in camera and then makes that determination. The government can always appeal back to us if they feel that determination is an error and against them. Why wouldn't that work here?
Your Honor, it's not the ordinary course where the very subject matter of the action is a state secret. The Supreme Court, by unanimous vote, made that clear in the Tenet case, and it reversed a decision by this Court where the Court believed that the case should go forward through the use of what it called creative in-camera proceedings.
Well, there's some question about Tenet and Totten, whether they really apply to this situation, because, of course, in those cases, one of the parties to the contract was the one suing to enforce it, in effect. And we don't have that here. What we have is the plaintiff alleging a different contract between AT&T and the government. So it seems to me that there really is some feature there that the Supreme Court focused on in those cases. Wouldn't you agree?
I agree that it focused on it, but what it said in black and white terms is that Tenet, the Totten is not a quote-unquote contract rule. And the Kaza case establishes that, because that case, after all, was not a suit against the government suing for breach of a contract. The Weinberger case establishes that, and it makes sense. If you think about it this way, if this action had been brought by AT&T against the government, suing for breach of some kind of alleged espionage relationship, I don't think there would be any serious argument, but they would have to be dismissed under the Kaza decision and the Tenet decision. And the result is no different, where a third party is bringing suit against AT&T and seeking through the courts to disclose the same type of information that AT&T would be seeking to litigate if it brought the suit on behalf of the government.
Let me go back to the discovery issue, because that follows up on Judge Hawkins as to whether the suit should be permitted to go forward in a preliminary way and then determine. So, for example, not with respect to the communication record. I want to focus again on the very program that you say does not occur, and that is the widespread communications. And I have looked at the discovery requests, many of which would probably be barred by the state secrets doctrine. But why couldn't there be documents which would not reveal anything about surveillance, but simply be executive branch statements, whether by declaration or in documents, that no one is authorized to do indiscriminate domestic surveillance without court order? What would be a state secret about such a document?
Your Honor, I want to answer your question, but I also want to say, just so that my co-counsel doesn't get deprived of his time, that we're dividing the argument here, and he's hopefully going to have 10 minutes of the time. So I see that I've gone over my 20 minutes, but of course I want to answer all the questions.
Well, we can help AT&T out. We just charge them a little overtime. That's all.
Thank you, Your Honor.
Or we can have them dial in and start pushing buttons, you know.
Judge McKeon, I mean, ultimately the answer to that is, regardless of what type of evidence plaintiffs might think that they could come forward with or that might exist, ultimately you would be asking the court to prove matters that are protected by the state secrets privilege, whether or to what extent any relationship existed, whether or to what extent any surveillance activities took place, and whether or to what extent any particular communications were intercepted.
What would be wrong with an appropriate official of the government signing the affidavit that Judge McKeon suggests?
Well, Your Honor, again,
first of all, would that be subject to state secret? The affidavit itself, a simple affidavit denying that the government has intercepted the telephone conversations of American citizens without a warrant?
As we indicated earlier, the government, the President of the United States, the Attorney General of the United States has made clear that the government is not doing that. But what would be subject to the state secrets privilege is the litigation of the veracity of that, because it would put the government...
Yeah, that brings my next question. You filed the affidavit, and then you explained to Judge Walker why it is you can't reveal the information behind it. At least the public has the benefit of a sworn statement from a public official that what they suspect is going on is not.
And again, Your Honor, if plaintiffs are willing to accept that today as a conclusion of this litigation, we'd be thrilled.
Well, we're not asking whether the plaintiff would accept it or not. We're asking really whether
you'll do it.
Well, whether it's so preliminary. We're just asking if, we take President Bush as he says it. It seems to me that that's based on, it could be not just a sworn affidavit, but there must be documents that say the same thing, whether from the NSC or otherwise. There would not be state secrets, because documents that would corroborate that and say essentially the same thing would be no more of a state secret than the statement, correct? If you had a document that said exactly that, would that be a state secret?
No, the denial itself, but going beyond that, and this is a critical point, going beyond that would put the court into the position of getting